Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santelle.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santelle.
Good morning. This is Jim Santelle, and yes, indeed, I am your host for this hour and also next hour right here on the media stations of Civic Media throughout the state of Wisconsin. This is our Saturday morning broadcast, every Saturday morning talking with you, reviewing, analyzing, summarizing those major events and stories in the news of America, of our state, and of the world, in areas of what? Of government and law and the aspiration for justice in all parts of our nation, our state, and our world. We are coming to you this morning from the studios of WAUK in downtown Waukesha, but once again broadcasting throughout the state of Wisconsin on many, many of our outlets throughout the civic media community. Delighted to have you with me this morning for this hour. Hopefully next hour too. We've got a lot on our agenda this morning. And as always, I'm joined in the studio here this morning by our wonderful producer this morning. Johnny is with me. And together we're also going to be taking your phone calls this hour and next hour as well. And we have a special phone number this morning, just as we did last week. This morning we've got a special phone number, and that is this. It is 414-441-2941. That number once again is 414-441-2941. Civic media growing, civic media developing in many, many areas. One day, perhaps we get our own area code. But this morning, we've got a special phone number for you. Again, one more time, it's 414-441-2941. And together with Johnny, I'm soliciting, I'm encouraging your phone calls, especially your inquiries about the subjects that we're going to talk about this morning, your perspectives on them, and the ways in which they may indeed influence your own lives and the lives of the people around you. As always, on our Saturday morning broadcast, we address those things that affect the aspiration for justice in America, government, law, lots of that to get to this morning as well. And in that context, we always ask and attempt, not always successfully, but we hope to answer three basic questions. Fundamentally, what happened? We have a primacy here on civic media focusing on facts, on circumstances, what we know for certain. It is not speculative. These are the things that we have confirmed and that we know to be true. And second, why are those things relevant? Why are we talking about those? Why are they material, significant in our lives? And finally, what, if anything, can and should we do in response to those things that we know, those things that are relevant and material in our lives? All of those questions asked and hopefully answered with your participation this morning and every Saturday morning on our broadcast. We do, as always, have an ambitious but well-achievable agenda for this morning, a syllabus that is going to include a number of different hot topics, decisions, issues, developments in the areas of law, government, and justice just this past week. I'm going to spend some time focusing in greater detail than we normally do on three major cases. We're going to do sort of a deep dive, almost a microscopic justice analysis of three major things that are happening or have happened just this past week. One of them is we're going to go back and talk about this major decision issued by the United States Supreme Court having to do with whether or not Donald Trump would be on the ballot in Colorado. We know the decision already. Not surprisingly, came out by the Supreme Court. We're going to talk about the majority and not really the minority opinions, but the concurring opinions in that decision, finding that indeed Colorado and other states do not under the Constitution have the authority unilaterally as states to remove a candidate from the primary ballot. So pushing back and telling Colorado you got this wrong. I want to spend some time talking with you about what 5 justices of the Supreme Court wrote, what they explained in terms of justifying their decision. And then significantly, I'm going to talk about what 3 other justices and yet one more justice wrote in concurrence, in agreement with the result, but not in the breadth, the extent of that result. I'm going to talk to you all about that, talking about this major case, one of three coming out from the Supreme Court having to do with Donald Trump. We know what the other 2 are as well. We know that one of them has to do with a case called Fisher and whether or not the charges against Donald Trump in the federal case against him, the so-called election interference case, a challenge in that case to one of the charges upon which that indictment is based. That's called the Fisher case, and we'll talk with you about something that happened, that is the scheduling of an oral argument in that matter that could dramatically impact the prosecution of that case, now coming up for April. And then we're also going to talk, of course, about the larger immunity decision, also coming up for oral argument on the last day of the court's term. Another big issue, another big event happening this past week. The Supreme Court announcing not only previously that it is going to be taking that case, granting the writ of certiorari, this agreement to review the case, and now setting it on for oral argument, all of that anticipating decisions. Yes, that's right, probably in June of this year. We're going to talk about what those cases mean, and then also the impact, the intersection of those litigation decisions upon our politics and our government, and specifically the election coming up this year. That is one of the areas we're going to spend some time talking about, a deep dive, kind of a microscopic justice view this morning. We're going to do that in two other areas as well. We know as well that the judge who's presiding over the Manhattan criminal case, the so-called catch and kill case, the so-called case involving hush money paid to at least one, if not two people, to keep their mouths quiet in advance of the 2016 election. We're going to talk about not only the scheduling of that before Juan Merchan, who is the judge who's going to be presiding over that case, but also about what the theories of prosecution are going to be. What is that case going to look like? Who's going to testify? What is that dimension of that case going to look like, again, in the news? And then we're also going to do the same. That is another deep dive, kind of a microscopic justice look at another case, one of these other cases. This is the Mar-a-Lago case. We're going to talk more about what's in front of Eileen Cannon right now. She is the district court judge who's presiding over the documents case. We're going to talk about the motions that the defense has filed in that case, seeking to have the case dismissed, truncated, in some way reduced. We'll tell you about those and describe what it is that Judge Cannon has in front of her now and in the future. Along the way, we are going to spend a little bit of time talking about the State of the Union this past week, a significant matter having to do with the interaction between, frankly, three branches of government, but at least two visibly on your television sets and your streaming media sources, between the President of the United States of America and members of the Supreme Court sitting right in front of him, just yards away. We're going to talk about why that's significant, exactly what Joe Biden said to them in connection with one of their major cases recently. You know what that is. That's the Dobbs case involving privacy rights under the Constitution. And then, of course, late-breaking news just yesterday. That is that Donald Trump, in yet another case having to do with the civil judgment previously entered against Donald Trump in the E. Jean Carroll matter. You may recall well, two much related trials in which she alleged that Donald Trump had not only sexually assaulted her in a department store in Manhattan in the mid-1990s, proved that to the satisfaction of a jury, and then also secured from him $5 million judgment, and then also an $83 million judgment. All of that resulting in a total judgment of somewhere just in excess of $90 million, with interest also ticking away on that. Significant news just yesterday, that is that Donald Trump posted bond for that, basically to ensure that he has the right, the prerogative, to appeal this case, that judgment, to the appeals court there in New York, finding that, hopefully, as he is going to maintain, finding that the lower court was wrong, the jury was wrong in making those determinations. That's going to be his argument on appeal. But in the meantime, he is posting that money. We're going to talk about what that means, where that money comes from, and of course, much related is the fact that he also has this huge, now approaching $500 million judgment coming out of the valuations case. That's a civil case as well, but again, pending in a state court. The judge there basically giving him a very limited deadline in which to either submit that amount of money or get a bond in place for that case as well. Lots and lots of debt at the heels and in the offices right now of Donald Trump as he goes ahead in all of these different matters. Lots of things on our agenda this morning. Appreciate very much your joining me for this hour And next hour as well, let me give you that phone number, that special phone number one more time. It's 414-441-2941. 414-441-2941. Again, Johnny and I delighted to take your phone calls and have you be a part of our discussion this morning. Part of our microscopic justice analysis this morning is going to be this major decision, not at all surprising, issued by the United States Supreme Court on March 4th. That was Monday. And let's begin by talking about the circumstances, the structure under which this case was issued. One of the first things that you will see if you pull up the opinion, and yes, indeed, I recommend that you take a look at it. It is accessible, even though we're going to spend a lot of time talking about its component pieces in the next few moments. The first thing you're going to see in that written decision are the words per curiam, P-E-R, new word C-U-R-I-A-M. What does that mean? What does per curiam mean? You will not see, as you will see in many other opinions, as we've talked about on this radio broadcast, the specific names of justices who have either written the case, who have concurred in it, dissented in it. You will see a little bit of that later on in the text of this decision, but the ultimate decision here is per curiam. What does that mean? Basically, it is Latin, as you can well imagine, many things in the law coming from the Latin language, not at all a dead language, by decision of the court in unanimous agreement. That's basically what it means. And yes, indeed, here you've got a unanimous decision, although you've got disagreement, as we will talk in just a moment or two, among at least 4 justices about the extent to which the Supreme Court went beyond that fundamental agreement, placing Donald Trump back on the ballot in Colorado, presumably also other places like Maine and Illinois that have likewise toyed with and were approaching the removal of his name from the ballot. In this case, a per curiam decision, a specific judge who wrote the opinion not identified. And as a result of that, what we know is that a majority of the Supreme Court, 5 members of the Supreme Court, we know who they are, even though their names are not here, because 4 others wrote in concurrence in agreement with that opinion, but came to some different results about the breadth of that opinion. We're going to spend some time talking this morning about what that opinion means in our deep dive, our focus on microscopic justice, on this case, Donald Trump versus Anderson. That discussion coming right up.
Are you telling me the things you're gonna do for me? Yeah, I ain't blind and I don't like what I think I see. Taking it to the street. Taking it.
And we are back this morning discussing a lot of things having to do with the United States Supreme Court, including this major decision, not one bit surprising based upon the oral argument of several weeks ago in this matter in which Colorado, at least a significant body of people, petitioned to keep Donald Trump in Colorado off the ballot there. Supreme Court making this decision just this past week, not one bit surprising based upon the oral argument, finding that these group of so-called respondents, that's how the court refers to them because they're responding to the petition here, the Supreme Court finding that they are wrong, that the state of Colorado cannot, should not constitutionally remove his name from the ballot. And how does the Supreme Court get there? Well, we're going to spend some time talking about the text of the so-called majority opinion. It is a unanimous decision, a unanimous judgment finding that Colorado is wrong, that the states in our nation do not have the capacity under the Constitution to remove a candidate's name from the ballot, but they get there in different ways. The per curiam opinion begins this way. It says a group of Colorado voters contend that Section 3 of the 14th Amendment to the Constitution prohibits former President Donald J. Trump, who seeks the presidential nomination of the Republican Party in this year's election, from becoming president again. The Colorado Supreme Court agreed with that contention, as we've discussed before on this broadcast, and it ordered the Colorado Secretary of State to exclude the former president from the Republican primary ballot in the state and to disregard any write-in votes that Colorado voters might cast for him. That's casting the basic foundational position of this case. And indeed, the first several pages of it, 2, 3, 4, are all descriptions of the procedural and substantive history that gets us there. And in the end, at the top of page 4, the Supreme Court announces, we reverse the decision of the Colorado Supreme Court. And then they go into a significant discussion about the ratification and the meaning of the 14th Amendment, expanding, as they say, federal power at the expense of state autonomy, and thus fundamentally altering the balance of state and federal power struck by the Constitution. They go on to say the Section 3 of the amendment restricts state autonomy, but through a variety of different means. And that, of course, presages their ultimate decision here. Goes on to announce this fundamental notion. The Constitution empowers Congress to prescribe how these determinations under this particular language of the Constitution should be made. The relevant provision is Section 5, which enables Congress, subject, of course, judicial review, to pass appropriate legislation to enforce the 14th Amendment. And so they go into the Section 5 of the amendment, and they say that's the animating portion of the language of the Constitution. And so identifying Section 5 as being critical when it comes to Section 3. A lot of interplay between the language in the 14th Amendment. The case, they say, raises the question whether the states, in addition to Congress, may also enforce Section 3. And again, they conclude that states may disqualify persons holding or attempting to hold state office, but the states have no power under the Constitution to enforce Section 3 with respect to federal offices, including the presidency. And that's the distinction that is all important. States have responsibility, authority to make decisions about state office holders and state candidates. But when it comes to the federal government, they find that under the Constitution, under the 14th Amendment, only the Congress can do that. They announce in our federal system, the national government possesses only limited powers. The states and the people retain the remainder. But under these circumstances, this particular statute holds. They go on to describe many of the positions of the Colorado plaintiffs, here described once again as respondents. They say that the states may enforce Section 3 against candidates for federal office. And they've gone on to say that the text of the 14th Amendment on its face does not affirmatively delegate such a power to the states. Looking again at the text of the Constitution itself, the terms of the amendment, the per curiam opinion says, speak only to enforcement by Congress, which enjoys the power to enforce the amendment through legislation pursuant to Section 5. That's, again, the fundamental notion here. And here is one of the critical findings early on in the opinion in which they dismiss the positions articulated and advanced and argued by the respondents. They say this: the only plausible constitutional sources of a delegation are the elections and electors clauses, which authorize states to conduct and regulate congressional and presidential elections. In other words, here is one option. Here's one possibility where the respondents, the Colorado plaintiffs, if you will, arguably could find some basis for believing that the states do have this authority. But then they go on to shut that down too. And they say, but there is little reason to think that those clauses implicitly authorize states to enforce Section 3 against federal office holders and candidates. Granting the states that authority would invert the 14th Amendment's rebalancing of federal and state power. And that's the key. That's the key. They look around, they say there's nothing else in the Constitution, including the elections and electors clause, that gives the respondents, the plaintiffs in the lower court, any basis for doing this. They also say that respondents have identified nothing in any tradition of state enforcement under Section 3 against federal officers. Looking to history, a lack of historical precedent. The Supreme Court, as you well know, spending a lot of time these days, especially when it comes to firearms cases and other major legislation, directing that the courts, the federal courts, and sometimes even state courts, to determine whether actions taken by the government is proper or not. You look to history. Now, there's an awful lot of disagreement, including my own, about that, but they often hearken back to things in the past, sometimes the distant past, and we've seen a lot of that again, as I indicated, in the firearms cases, which we will talk about again as those cases are decided in June. Here again, they look back somewhat to history and they say, we find nothing in historical precedent to provide, as they describe it, a telling indication of a severe constitutional problem with the asserted power. Nothing about history, nothing would suggest in our own historical past that would support the position by the respondents, the people in Colorado who wanted to keep Donald Trump off the ballot there. Instead, they say it is Congress that has long given effect to Section 3 with respect to would-be or existing federal office holders. And they describe then a history after the ratification of the amendment in which that congressional authority is not only identified but exercised in a major way. Moreover, they say permitting state enforcement of Section 3 against federal office holders would raise serious questions about the scope of that power. And here's the real key. We know well from the oral argument that most of the justices of the Supreme Court were concerned about this so-called patchwork. If indeed Colorado and perhaps Maine, Illinois, other places around the nation follow the so-called Colorado lead, some will, some won't, we'll end up with a patchwork of ballots, some in which Donald Trump is on the ballot, some which he is not. And there was major concern, frankly, from all sides of the so-called political aisle at that time about that. And they identify this as a major problem. They say with respect to Section 3 enforcement, the presidency would have additional implications, heightened concerns here. Go on to say, in the context of a presidential election, state-imposed restrictions implicate a uniquely important national interest, and then go on to say that these conflicts would result in this patchwork. Right after this, we're going to talk more about what that patchwork is, how it's described, and then talk in greater length about the so-called concurring justices and the problems that they had with the outline that I have just described, again, identifying the content of the 5 major Supreme Court justices whose words we are now hearing. Stay with us for that important discussion. We are back talking this morning about the United States Supreme Court, as we often do, and particularly focusing upon this decision of just about a week ago, last week, Monday, finding that indeed Colorado must have Donald Trump's name on the Republican primary ballot. A unanimous decision in terms of the judgment, the final result, but not unanimous in terms of the content of the decision. We're spending some time right now talking about what at least 5 members of the Supreme Court not only articulated, but what they said about who can, in fact, enforce the 14th Amendment. Just before our recent break, we were talking about this notion that there could be, as many of the Supreme Court justices said during oral argument, a patchwork of states out there, if indeed Colorado, other places like Maine, Illinois, around the country, some 30 different states looking at various iterations of this issue. In the end, the Supreme Court says that is a key element of this. Conflicting state outcomes concerning the same candidate could result not just from differing views of the merits, but from variations in state law governing the proceedings that are necessary to make Section 3 disqualification determinations. That's the key language, and that's what is reflective of the oral argument of a number of weeks ago. Among other things, again, this per curiam opinion says this: some states might allow a Section 3 challenge to succeed based upon a preponderance of the evidence. That typically means 51%, just over 50% in terms of compelling evidence, while others might require a heightened showing. That's the burden of proof. Certain evidence, like the congressional report on which the lower courts relied here, might be admissible in some states, but inadmissible hearsay in others. They're talking about the evidence rules that could likewise result in different conclusions. Disqualification might be possible only through criminal prosecution, as opposed to expedited civil proceedings in particular states, an issue we've also discussed. That is, how, again, do you enforce this If one state were to say only a criminal prosecution can provide a predicate for disqualification, other states say no, a civil proceeding could do just that. In the end, here is the penultimate language in the per curiam opinion. The Supreme Court says this: the patchwork that would result from state enforcement would sever the direct link that the framers found so critical between the national government and the people of the United States as a whole. But in a presidential election, the impact of the votes cast in each state is affected by the votes cast, or in this case, the votes not allowed to be cast for the various candidates in other states. An evolving electoral map could dramatically change the behavior of voters, parties, and states across the country in different ways and at different times. That disruption would be all the more acute and could nullify the votes of millions and change the election result if Section 3 enforcement were attempted after the nation has voted. Nothing in the Constitution requires that we endure such chaos arraying at any time or at different times up to and perhaps beyond the inauguration. That chaos language, that concern about the patchwork, that in the end is what the Supreme Court is concerned about. Now, what does the Supreme Court not say in that per curiam opinion written by, we don't know who, but certainly agreed upon by 5 members of the Supreme Court? The language agreed upon, the result agreed upon by all members, but getting there in a different way. What the Supreme Court does not say is whether or not there was an insurrection on January 6th. They don't touch that issue at all, which was a subject, of course, of the lower court matter. It was a subject of the Colorado Supreme Court case. They also do not identify Donald Trump as being responsible for that insurrection. And indeed, although his name appears here, he is not identified in any way. The analysis does not revolve around a finding of an insurrection on January 6th, describing it that way, describing it as rebellion, as the language of the Constitution also says. They don't even come close to that. That's not even addressed, nor do they place Donald Trump anywhere in the middle of that process. Likewise, they don't comment upon the procedural aspects of the lower court, the trial court proceedings, the decision made by the Colorado Supreme Court, other than to say that states like Colorado do not have the authority under the Constitution, under Section 3 of the 14th Amendment, to enforce this. It's only the Congress. And indeed, that's where there is a dissent with a small d between 5 members of the court and 4 others. 4 others. We're going to talk right now about what 3 of those 4 have also said. What we have are 2 concurring opinions, concurring in the judgment in one case, concurring in part, and concurring in the judgment in another case. In other words, we agree with the result, but we're getting there, and we're going to say some things about what the majority has said with which we disagree. So we have, not surprisingly, Justice Sonia Sotomayor, Justice Elena Kagan, and Justice Ketanji Brown Jackson saying, you know what, we agree. In the first couple of pages of their concurring opinion, they make clear that they agree that indeed only that these states do not have the authority here to do what they are doing. However, they disagree with the additional language about the exclusive nature of what the Congress can do. They say the majority rests on the principles when it explains why Colorado cannot take the petitioner off the ballot. State-by-state resolution of the question whether Section 3 bars a particular candidate for the president from serving, the majority explains, would be quite unlikely to yield a uniform answer consistent with the basic principle that the president represents all the voters of the nation. And they go on to say that notion about state authority provides a secure and sufficient basis to resolve this case. Don't need to go any further. Don't need to delve into this issue about congressional authority. To allow Colorado to take a presidential candidate off the ballot would imperil the framers' provisions of a federal government directly responsible to the people. They agree. They agree with all of that language that in the majority per curiam opinion establishes that states cannot do that. And then you have the word yet in a second section of this concurring opinion, yet. The court continues on to resolve questions not before us. In a case involving no federal action whatsoever, The court opines on how federal enforcement of Section 3 must proceed, and that's what they disagree with. That's what the three say, you know what? The limitations imposed by the majority cannot stand. Section 3 simply states, they say, that no person shall hold positions in offices if they're oath-breaking insurrectionists. Nothing, they say, in that unequivocal bar suggests that implementing legislation enacted under Section 5, once again, this other implementing provision, is critical. They go on to say it is hard to understand why the Constitution would require a congressional supermajority to remove a disqualification if a simple majority could nullify Section 3's operation by repealing or declining to pass implementing legislation. In other words, they're looking to the internal language of this particular constitutional provision and say, doesn't make sense. What the other five are saying, our brethren on this court, simply doesn't make sense. Ultimately, they say, under the guise of providing a more complete explanation for the judgment, again, that's invoking the language of the five, of the per curiam opinion, the majority resolves many unsettled questions about Section 3. It forecloses judicial enforcement of that provision, such as might occur when a party is prosecuted by an insurrectionist and raises a defense on that score. The majority further holds that any legislation to enforce this provision must prescribe certain procedures tailored to Section 3, ruling out enforcement under general federal statutes requiring the government to comply with the law. All of that, they say, goes far, far beyond what the Supreme Court needs to do. And indeed, they say this, what it does today, the court should have left undone. They finally say Section 3 serves an important, though rarely needed role in our democracy. The American people have the power. This, again, is the three who are in disagreement with the extent of the decision. They say the American people have the power to vote for and elect candidates for national office, and that is a great and glorious thing. I suspect, we hope, that all the members of the Supreme Court would agree with that. The men who drafted and ratified the 14th Amendment, however, had witnessed an insurrection and rebellion to defend slavery. They wanted to ensure that those who had participated in the insurrection and in possible future insurrections could not return to prominent roles. Today, the majority goes beyond the necessities of this case to limit how Section 3 can bar an oath-breaking insurrectionist from becoming president. Although we agree that Colorado can enforce Section 3, we protest the majority's effort to use this case to define the limits of federal enforcement of that provision. Because we decide only the issue before us, we concur only in that judgment. Strong language, sort of chastising the majority for their extensive opinion in this particular matter. And then we have a one-page, a two-paragraph concurring opinion by Justice Barrett, almost as equally interesting and even head-scratching. She says, you know what, I also agree with the other five who say, you know what, Colorado cannot do this. But I also come to this notion that the majority has gotten there on a different path. And she says the majority's choice of that different path leaves the remaining justices with a choice of how to respond. In my judgment, again, this is Amy Coney Barrett speaking alone. She says, this is not the time to amplify disagreement with stridency. That is a comment upon the language by her fellow justices. The court, she says, has settled a politically charged issue in the volatile season of a presidential election, and then goes on to say this, particularly in this circumstance, writings on the court should turn the national temperature down, not up. For present purposes, our differences are far less important than our unanimity. All 9 justices agree on the outcome of this case. That is the message Americans should take home. Fascinating language. I would offer to you that while, yes, she joins both the 5-member majority, if you will, and also joins her 3 others on that side of the fence on this case in saying the majority has limited too much the enforcement aspects of the provision of the Constitution itself, she then goes on to talk about something that's far beyond the judicial command to engage in an application of the law to the facts and the facts law. She is now commenting on the impact of what decisions can have in our national landscape. She's concerned about turning the national temperature down, not up. And I would offer that there are branches of government, they're the legislature, They're the executive branch that should be concerned about the extent to which our population generally has its temperature higher and lower. They can pass legislation to address that. They can pass environmental legislation, educational legislation, civil rights legislation, all kinds of things to change the ways in which our temperature in this country is higher or lower. But the Supreme Court and courts are not in that political business. Likewise, the executive, governors, and presidents should indeed be concerned about the temperature among the population, but they do not need to be things that are in the ambit of the Supreme Court and judges. I would offer that language, much criticized out there, goes way beyond making a legal determination and basically says because we are living in this volatile time when a lot of the language is incendiary, she suggests even the language of my colleagues on the Supreme Court, because of all of that, we need to be thoughtful about what's going on beyond the law and beyond the facts and beyond this case. We need to turn the temperature down. That's what we are doing here. That's what we encourage the people of the United States of America to do. I would offer that while the result is one of those things that reasonable people can differ on, again, the extent to which the Congress does or does not have authority. Who is the authority to enforce Section 3? The Supreme Court tells us now it's only the Congress. That debate will certainly continue. But when it comes to issues about the impact upon the country of decisions made, cases like Brown versus Board of Education, 9-0, the court there decided that was what the law and the facts commanded, that separate educational facilities are inherently unequal. They were not concerned, if you will, about the impact. That's for the legislature. That's for the executive branch. And they made that decision based upon the jurisprudential principles set forth in Brown versus Board of Education. Donald Trump versus Anderson. That case decided just this past week. More on the Supreme Court, what is coming up in the weeks just ahead, right after this.
You're listening to The Shaw, WAUK, Waukesha's home for the Town Hall Ball Show.
Program. This is the final segment of our first hour talking about the Supreme Court, this major decision issued in one of three cases involving Donald Trump that are pending in front of the United States Supreme Court. We'll get to those in just a moment or so. Something else happened in connection with the interplay between branches of government, Article 1, Article 2, and Article 3 on this past week, and that is the State of the Union. At an appropriate point during the course of his presentation to the nation and to members of the Congress, the United States President, our United States President Donald Trump, brought up the majority's opinion reversing Roe versus Wade. That, of course, is the Dobbs case, finding that there is not a privacy right in the Constitution with respect to reproductive rights and abortion in particular. He began to read an excerpt during the course of the State of the Union of that decision when he began a brief aside, and he looked right at the justices who were appearing just yards away from them, all the branches of government there represented, and he said this. He said, "With all due respect, justices, women are not without electoral or political power." And then in what appeared to be a fairly ad-libbed moment, he added, "You're about to realize just how much." And of course, the reaction around the nation and also in the well of the Congress to those comments. This is not only a visual, a physical depiction, if you will, all three branches of government right there in the same well of a government office. That is the well of the House of Representatives. President looking at the Supreme Court and chastising them for their decision in Dobbs, saying that you don't appreciate what you have done. You will see, Joe Biden says, the impact of your decision in Dobbs in the coming time. And indeed, we've already seen a lot of that in states around the nation, an issue plainly not completely resolved. It's going to have ramifications for many years. A fascinating thing. Don't know if it's unprecedented or not, but the notion that a sitting president in the State of the Union, under the Constitution, required to give this report to the nation on the State of the Union, looks at the Supreme Court justices in his physical presence and says, you don't know what you have done. You don't know what you've got unleashed. And you will see the impact that women and voters generally have. What a fascinating civics presentation, a civics event in our nation in a part of the State of the Union. Let's talk more about the Supreme Court and what's got coming up. Supreme Court has scheduled oral arguments in March and in April. March 18th, 19th, 20th, 25th, 26th, and 27th. April's got 10 more oral arguments also coming up. The 15th, 16th, 17th, the 22nd, 23rd, 24th, and 25th. They're very busy, and then they're done. Then they're done with oral arguments for this term, and then we await the decisions that are coming up, presumably in June. We know that the Supreme Court has 62 cases, including the 3 that involve Donald Trump. 2 of those cases come from the 7th Circuit, 10 of them from the 5th Circuit, 11 of them from the 9th Circuit. What do we know? We know that on the 18th of March, this case called NRA versus Vula, which is a major case involving the interaction, if you will, between the First Amendment and the capacity of a government regulator with respect to discouragement of regulated entities to engage with, frankly, it's the NRA. It's a gun case as well. Vula also being argued on March 18th. On March 26th, FDA versus Alliance for Hippocratic Medicine, that's the mifepristone case. They're going to be arguing about whether or not mifepristone, authorized by the FDA for almost a quarter century, should in fact be pulled based upon the conclusions of a federal district court judge in Texas and affirmed for the most part by the Fifth Circuit Court of Appeals. Didn't go quite that far, but limited access to mifepristone. That's coming up on March 26th. Then the other 2 major cases coming up in April. On April 16th, the second or the third, depending upon how you're counting it, this Fisher case, which I mentioned repeatedly, the third major case having to do with the legitimacy of the statute under which something in excess of 100 protesters, rioters on January 6th have been prosecuted, found guilty, judgments entered against them. Mr. Fisher raises this argument that that particular statute, because it talks about a corrupt way of doing things, cannot apply to his particular conduct, depending upon how the Supreme Court hears that case and depending upon how it resolves it, now presumably in June. That could have a dramatic impact upon the criminal prosecution pending down the road in front of Judge Chutkan. Why? Because that statute is also the predicate for 2 of the 4 counts in the election interference case in that federal case. And finally, on April 25th, the very last day of the court's hearing oral arguments this term, they're going to be hearing Trump versus United States. And yes, indeed, that's the immunity case. We've talked a lot about this. You've heard a lot about this. This is the decision to review what the lower court has done, what the appeals court has done, finding that indeed the United States of America shed the monarchy well over 200 years ago, and that we do not have kings as presidents, presidents as kings, that there is no immunity. That's the decision, the very compelling decision made by the lower district court, made by the appellate court, and the Supreme Court is now taking that case. The impact of doing that, of course, and we have to assume that all 9 justices, let us anticipate that every single justice on the Supreme Court will be saying that no, indeed, no such immunity applies. The significant event, of course, is we're not going to get that decision until June. And what that means as a practical matter, as we talked last week, is that Tanya Chutkan will not get this case back from the Supreme Court until sometime in mid, perhaps even late June. She's talked about giving the parties an additional 80-some days in which to address pretrial matters. And the reality is that that case, which will probably take 2 months, maybe even more than that, to select a jury, present evidence, have the jury deliberate, she's got to find, that is the district court judge, probably a 2, maybe even a 3-month period of time in which to try that case. It brings us right up against the election on November 5th, maybe even goes beyond it. An awful lot of people realizing now that the Supreme Court's decision in scheduling, Fisher in part, but more significantly, Trump versus U.S., going to have an impact on whether or not the American population ever sees the result before the election of those basic insurrection, those basic interference counts brought by the grand jury against Donald Trump. And that is significant, not only in 2024, but also with respect to the jurisprudence of the United States Supreme Court. In our second hour, we're going to move off the Supreme Court and talk about what's happening in other cases in Manhattan and also in Florida. I encourage you to join us for that discussion and be a part of our discussion at 414-441-2941 here on our Saturday morning broadcast.
Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santelle.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santelle.
Good morning. This is Jim Santelle. This is the second hour of our discussion on this Saturday morning. And we are delighted to have you with me and with Johnny, also my excellent producer here in the studios of Civic Media, right now coming to you from the studios of WAUK in downtown Waukesha, but broadcasting throughout the state of Wisconsin and inviting, as always, your comments, your questions, your inquiries, especially at a special number this morning. That number is 414-441-2941. In our first hour, we spent a lot of time doing a deep dive, kind of a microscopic review of what the Supreme Court did, its decision, this major decision, not surprising, to find that Colorado cannot keep Donald Trump off the primary ballot, providing in direction and instruction, if you will, for all of us about what Section 3 of the 14th Amendment does and does not say. Some internal dissent, if you will, even though agreement on the ultimate result about the lack of state authority to enforce Section 3 of the 14th Amendment. A lot of justices, at least 4 of them, saying that the Supreme Court's opinion is much too narrow, much too broad, rather, and that they did not have to go in that area. A much narrower approach would have been appropriate. This hour, we're going to be doing a similar, deeper dive, a little bit more microscopic analysis of 2 other things, 2 other cases pending out there. We know that in Manhattan, the next trial scheduled, it begins on March 25th, just a few days from now. That is the so-called Manhattan catch and kill. That's the case involving allegations that Donald Trump engaged in an effort to undermine and to violate New York law when it came to handling financial records, paying off people to be quiet about his affairs and things in his personal life that would have impacted the presidential election. We're talking about what it is that the government, Alvin Bragg, the DA, is going to present there. Kind of a deep dive in what that case is going to look like if indeed it goes to trial on March 25th. And then also in this hour, we're going to do a similar deep dive, some microscopic analysis of where that Mar-a-Lago case stands. What's going on right now? What are the motions that are pending in front of Eileen Cannon? What do they say? What does the defense say? What do the prosecutors say? Where is that case in terms of its status, and what should we expect down the road? But before we do all of that, again, an ambitious agenda for this hour as well. Before we do that, we are going to take at least one caller right now. Joe, delighted to have you with me this morning on our Saturday morning broadcast.
Thanks, Jim. I think that this microscopic detail into one court case is really fascinating, and I'm looking forward to your analysis of other cases that come up. It's really a great way to go to just really dive in head first. So I wanted to just talk about one element that came up in the last hour, and that was the language used by Supreme Court Justice Amy Coney Barrett, when she used the language that she felt it was important to, quote, turn down the temperature of the national scene, if you will. And you responded that this was a rather fascinating thing for her to say. I think that's very generous of you to use such
Right.
gracious language. I would say that it's not part of their purview at all to be concerned about the national temperature. And I would argue that the insertion of that and the fact that other justices did not respond to it, or more in particular that that Roberts did not respond to this, is really not good, because it's taking what the justices do. It's commenting and saying that taking what the justices do, we won't do anything to rock the boat, which of course is horsepucky because she was signed on to Dobbs, which clearly rocked the boat. That was 50 years of established precedent that went right out the window, and she was happy with that. So what you are getting to is, who decides what's volatile times? Who decides how it's turned down? Who decides, when we can comment in that way on cases? And I think it's an incredibly bad precedent. And I mean, obviously she's an idiot for bringing it up, but I am just amazed that, that the Chief Justice did not look at that and say, no, don't put that in there. That's not what we do. Because what does that say as we're coming around the bend to some very major cases, such as the immunity case coming up? Well, times are really volatile, so we won't do anything that we're supposed to do with the immunity case. We'll just try to turn the temperature down. That's not your job.
It is
your
not.
job is
Right.
is to look. Yeah, so I'd be curious to hear a little bit more reaction from you on what this might portend, since it wasn't slapped down by the Supreme Court, the Chief Justice, to sort of say this isn't our job. It really looked juvenile to me, and it really looked like mommy says, kids should behave. Well, that's not your purview either. So excuse me for being rather blunt, and I appreciate your more judicious way of saying it, but I'd be curious to how those comments, what that might portend as we're looking at this immunity case, for example.
Absolutely.
Thanks a lot, Jim. I appreciate it.
Joe, as always, appreciate your comments, and I concur in all of that. As I indicated in our first hour, these are things for the legislature to take care of, right? These are things that the people we send to the House of Representatives, United States Senate, should they be concerned about the atmosphere of the nation? Yes, they should. And they should be passing legislation that addresses those kinds of things in the areas of law enforcement and academics and commerce and agriculture and environment, all those kinds of things. They should be concerned, and they should be reactive to what's going on there. Likewise, the president, even governors in the state systems, should be attentive to and responsive to the concerns, the atmosphere, as Amy Coney Barrett described it, as Joe, you've invoked it, the temperature of the constituency. Those are the branches of government that decide these things. And I think you make a great point, Joe. Beyond just the impropriety under a constitutional structure, what is the precedent that this sets in terms of at least her approach to the future? When it comes to these other major cases, Fisher deciding whether or not half of the case involving Donald Trump should be tried down the road, whether or not he has immunity. Those are things that are also raising or lowering the temperature of the population generally. Judges decide what the law is, and they apply that law to the facts of the case. And I used in the last hour the example of Brown versus Board of Education. Controversial? You bet it was controversial back in 1954 when the Supreme Court reversed decades, arguably our entire nation's understanding about education, the notion that separate school systems, separate institutions are inherently unequal when it comes to race. That was huge. Was the Supreme Court concerned? Sure they were, because they're members of our government and they're part of our national representative way in which we do government, if you will. Is it appropriate for them to have that concern that they themselves individually might have? Should that animate the decision about what the law says? Absolutely not. And so you get a 9-0 opinion in that case. I agree with you, Joe. This kind of language does not only open the door for her, but others to say, well, gee, if that's the role of the Supreme Court, what does the Congress do then? What is the role of the executive branch? They shouldn't be in that business. And to your point about the lack of any comment from either the other three, who again took objection to the decision of the majority to indicate that only the Congress can interpret the Constitution in this area, and also the majority itself, the Chief Justice. There's a paragraph at the very end of the per curiam decision in which the Chief Justice, arguably, assuming that he was the one who at least put his imprimatur on this language, he talks about the opinions written by the others. He says, so far as we can tell, they, that is Sonia Sotomayor and Elena Kagan, Ketanji Brown Jackson, and Amy Coney Barrett, as far as we can tell, they object only to our taking into account the distinctive way Section 3 works and the fact that Section 3 vests in Congress the power to enforce it. Those are not the only reasons the state lack power, but they're important ones. So he does respond to what he anticipates is coming in the next pages, and this goes to how it is these cases are decided. All of them know what they have said, and that's why in so many of these cases, whether there are concurring opinions, dissenting opinions, you get arguments right on the page. You get concurrences that say, I agree with this portion of our overall opinion, but I reach it in a different result. You get dissents that say, you know what? The majority is completely wrong, and it is as if they are arguing on the page about the very merits of the case in front of them. That happens all the time. You see that a little bit here when Amy Coney Barrett is chastising others about their language, and you see John Roberts also saying, you know what? All of you four have failed to understand the breadth of our decision. And the point that you make, Joe, is they've got the capacity to do that. Nobody responded to Amy Coney Barrett saying, you know what, Associate Justice Barrett, you have your right to have your views on this. And yes, indeed, you can print this. It is for what it's worth. It is not the law of the case. And it will be cited down the road, but it's a concurring opinion. The law of this case, of course, is a per curiam opinion of the 5-member majority, but still, it will be invoked as a notion that the Supreme Court should, in fact, be responsive to and reactive to what's going on out there. That, as you indicate, Joe, I agree with you, is a major concern. And none of the other justices in these writings that do, in fact, go back, they exchange these back and forth before it goes to the printer and before it's released to all of us. They know what they're going to say. They had that opportunity. They did not do it. What does it portend for what's coming up in June, not just in these other cases, but in all the other cases that we have also talked about? They're going to change the way in which we think about our lives. We've talked about these major gun cases that are pending, very significant, coming up in June. We've talked about these social media cases. And as I've said before, this major series of cases involving the likelihood that the United States Supreme Court is going to dropkick, get rid of this doctrine called Chevron, applying deference to agencies, acknowledging the expertise and the experience that is inside our federal agencies. It's an attack upon our agencies. We will see what the justices say in June about all those very important issues, and in many others among the 62 cases pending before the Supreme Court right now. They should be focused upon jurisprudence, and that means they apply the law to the facts to the law, and tell us what it is. They are aware of the fact that they're living in a world, that they're living in a nation that does, in fact, respond, but that should not be animating their decisions. And plainly, Joe, as you indicated, when it came to the Dobbs decision, they had to have anticipated the kind of thing that the president just this past week chided them for. That is, you have unleashed something. You had to know that was happening, and you went ahead and you did it anyway. You will see what the power of voters and the power of women is in America. All of these things, all of these rule of law issues, much intertwined, much connected in the history of our nation just this past week. More of all of that coming up, more discussion, a deeper dive into other cases right after this. This morning, a bit of a deeper dive, a deeper analysis into some of these things going on in our nation right now. We spent a lot of time talking about the significance of this Supreme Court case. We know that there are 2 more coming up, as we mentioned. We've got this immunity case going to be argued before the Supreme Court on its very last day of oral argument in April. We've got this Fisher case. It also goes to the legitimacy of the statute under which at least 100 or more people were prosecuted for the riot at the Capitol, also the predicate for 2 of the 4 counts alleged against Donald Trump by a grand jury in the interference case that is now before Judge Chutkan ultimately, but really pending right now before the Supreme Court on whether or not this immunity issue applies. A lot of focus on those cases, a lot of focus as well on the Georgia case, which is, again, one of the 4 criminal cases with which Donald Trump needs to address and be involved in the future. One of the other cases, however, among that 4 is the so-called Manhattan case. And of all of them, this is the one that probably has the most likelihood of actually going to trial. The judge in that case, his name is Juan Merchan. He has said that he will begin picking a trial on March 25th, just a couple of weeks from right now. So that looks as if that may in fact happen. That case, too, will take weeks, arguably months to try, lots of things to do there. And I'm going to spend some time this morning talking about what we can anticipate. What is this case all about? Because in many ways, it is identified as people as the least serious among the cases. It's the one that has this salacious aspect to it, sort of indicating that a lot of the weighty issues of the others are not involved in this particular case. And I would object to, and I would take exception to that assessment that this is not as significant, because in many ways it is also an election interference case. It is in many ways, as I've said in other settings here on civic media, it is also an origin story for Donald Trump. It's the first time that we saw him engaging in allegedly criminal conduct, not yet proven. He is presumed innocent until proven guilty. First time we see him engaging in this case in a violation of at least state law when it comes to trying to influence the election. The hush money case is arguably not just an election interference case, but also politically one of those that Donald Trump is probably most concerned about, because on the eve of this campaign, and we're now into it, it's not just the eve anymore, we're right in the middle of the daylight here, but certainly as the race ramps up in the weeks and months ahead, the fundamental notion here is that Donald Trump falsified some business records as a part of his scheme, his plan, his design to buy the silence of a porn star to keep her from going public with claims that the 2 of them had an affair. And as this trial draws nearer, later this month it's going to start, it's becoming apparent that prosecutors are going to likely tell a wide-ranging story that, yes, indeed, is full of some of those tabloid details and some of those headlines. And some of those can additionally be very embarrassing, not only to Donald Trump, but to his family. We're going to talk about why it is that Alvin Bragg is going to ask the judge, Merchan, there to permit him to present evidence beyond the narrow financial transactions. The hush money case, again, being prosecuted by the DA. His name, once again, is Alvin Bragg. And it's based upon this tale of extramarital sex, these business records, political animations, all kinds of things. The basics are these. And again, it's the underpinnings for the specific allegations in the indictment that's going to trial. Again, Donald Trump presumed innocent until a jury returns a verdict, if ever, finding him guilty. The waning days of Donald Trump's first run for the White House, we know that. Porn star named is Stormy Daniels threatened to reveal an affair that she says she had with him. Now, he maintains to this day this never happened. And plainly, that revelation itself would have been a scandalous event, a development that could have damaged his campaign. That's one of the theories that Alvin Bragg is promoting in his trial, which is coming up fairly soon. So according to the prosecutors, and yes, indeed, their star witness, and he's back again. His name is Michael Cohen. He is the former fixer. He himself has suffered a federal criminal conviction for lying to Congress, engaging in other federal crimes. He is going to be one of the principal, hopefully not the exclusive witness, before the jury at that time. That according to Michael Cohen, Trump arranged to buy the silence of Stormy Daniels. In so doing, employees working at the direction of Donald Trump falsified a series of invoices and checks and ledger entries to cover what was really going on here. So on that fundamental basis, Alvin Bragg has recently asked the judge, again, his name is Juan Merchan, who's presiding over this trial, to tell this much broader story about what actually happened here, and saying it's not just this single secret payoff, but actually three of them at the time. They also want to relate in detail how Donald Trump used his ties to the publisher of a supermarket tabloid to stop these embarrassing accounts about him from ever seeing the light of day. He's going to talk about that as well. And that is known as the catch and kill process. Catching the story inside the journalistic world, killing it so that no one sees it. Alvin Bragg intends to present that story as well. And as if that's weren't enough, we're also going to hear, again, we've seen a lot of this before. It's going to come all back, all resurrected in this trial. Prosecutors, Alvin Bragg, also want to introduce evidence about the infamous, remember this, the Access Hollywood tape. And that's the tape that surfaced in the very closing weeks of the 2016 campaign and captured, again, this salacious conversation, this conversation from years earlier when Donald Trump spoke very openly, brazenly, obscenely about grabbing female body parts without permission. I'm not going to describe the specific language there. You know, regrettably, that is now regrettably in the history and in the annals of campaign history in America. But that was the Access Hollywood tape, and we're going to hear about that again because it's a part of this broader story that Alvin Bragg is going to tell beyond just the specific financial transaction. Now, you may ask, well, gee, how do you get to do this? Well, all kinds of circumstances where prosecutors, including me in the 30 years that I did criminal prosecution, also civil litigation, have the capacity with judicial permission by the court to present evidence that provides context, provides support, provides the jury with analysis of the central charge. And so Bragg wants the jury to hear about the hush money given also to a woman named Karen McDougal, who is a former Playboy model who also claims that she had an affair with Donald Trump. Again, a similar event. Now, usually under the evidence rules, you can't introduce specific events to suggest that the behavior that you're charged with in a particular case is similar to what you've done in the past, suggesting that because you did it before, you did it again here. That fundamental notion is basically contrary to the evidence rules, but all kinds of ways with argument to the judge and permission by the presiding judge to get that information in if indeed it is relevant to the jury's understanding, provides evidence that gives them some context for it, and helps them to explain it overall. That McDougal payment between Trump and Michael Cohen was apparently captured on an audio that was recorded by Donald Trump. All of that from the DA. He also wants to tell the jury about a payment reportedly made to a fellow named Dino Sajudin, Sajudin. He's a former doorman at the Trump Tower in New York to keep the doorman from going public with an apparently baseless allegation that Trump had fathered an out-of-wedlock child. That's also going to be a part of the presentation. When we come back, more of what we can anticipate in the trial coming up later this month in a state court in Manhattan. Saturday morning discussion of all things government and law and the aspiration for justice in America. We're chatting right now. You're doing a deeper dive into this trial that probably will start on March 25th in a state courtroom in Manhattan. This is the so-called hush money case. This is, as I've described it before, is one of the 4 criminal trials pending against Donald Trump. It may well be that is the only trial among the 4 actually to go to trial before the election on November 5th of this year. And so it's significant that on March 25th, Juan Merchan, the judge, has indicated he's going to begin jury selection in this case. And between the today's date and the date of that jury selection, the judge is going to be wrestling with hearing arguments from the attorneys in connection with various motions, various requests that they're all making. And we're talking now about those requests, those motions, those petitions made, in this case by the prosecutor, about the extent to which the evidence will include things beyond the narrow specifics in the indictment, including the payment of monies to Stormy Daniels. And so, among other things, as I indicated right before our discussion break, Alvin Bragg intends to tell the jury about this payment reportedly made to a former doorman. And the allegation itself apparently is unfounded, but nonetheless, it provides insight into Donald Trump's approach to anything that would be contrary to his best interest publicly. This doorman apparently came forward with, again, a baseless allegation that Trump had somehow fathered an out-of-wedlock child with one of his housekeepers. Unfounded, but nonetheless, Donald Trump apparently it makes a payment to him to keep him quiet as well. And the purpose of all of this additional language, all of this additional evidence being told about the circumstances, is to provide the necessary background to the jury and to clarify fundamentally what we've always talked about in connection with criminal cases, and that is the motive and the intent as Election Day 2016 was approaching. What did Donald Trump intend to do in all of these instances? What was the overall scheme? What was his motive? He was trying, according to the prosecutors, to keep this information from the public domain because he felt strongly that it would have an impact upon voters going to the polling booths, would diminish the chances that he could be elected to the presidency. And so he does all of these things, according to Alvin Bragg, in support of this overall approach that reveals his intent to do this. Now, not surprisingly, Donald Trump's lawyers are pushing back hard on this, and they have asked Judge Merchan to keep Alvin Bragg from making any arguments that Donald Trump was seeking in any way to influence the election by squelching, by suppressing any of these negative stories. And significantly, in an effort to reframe the case entirely, which defense attorneys can do, that's a part of the process, to offer a different set of understandings to the fact-finding jury, the attorneys for Donald Trump will probably say that he wasn't committing fraud by making these hush money payments, but was instead merely seeking to prevent adverse publicity about himself from getting out. What was his motive? It wasn't about the campaign, they will say. It was instead simply to prevent this adverse publicity about him as a businessman, as an individual, from getting out in the public domain. They will go on to say, as they have already in some of their motion papers, candidates are not required to disclose everything about their personal life during an election, and attempts by a candidate, this is what the defense attorneys are saying, to keep certain matters personal are neither inappropriate nor illegal. And it's on that basis that the attorneys for Donald Trump will ask Judge Merchan, contrary to what Alvin Bragg has asked, to keep all of this additional evidence, this qualifying, this context-providing evidence from the jury's view during the course of this. And of course, the other portion of this, as I indicated at the start, is that the exposure of all of this, once again, the Access Hollywood tape, the McDougal aspect of this, the doorman, all of this, what comes back, not new in the public domain generally, but reminding people once again, as we have not heard since 2016 and 2017, and even some of the years after that, this is all now going to come back, underscoring once again this notion that Donald Trump had a personal life that was and is salacious. That is also going to be impact, and also the reason why defense attorneys are going to be arguing strongly to Judge Merchan about not permitting this evidence to come in. These are all pretrial motions. All these kinds of things need to be decided between now and the start of the trial. They can also be raised, of course, during the pendency of the case itself. The attorneys can raise objections based upon relevance and focus, but the judges traditionally will make determinations about these large bodies of evidence in advance of the trial, not only so that everybody knows how long they will take, but that there are no surprises coming up during the course of the trial. You don't want to have a jury suddenly suspended in its review of the evidence if you, in the middle of a trial as the judge, need to resolve this major issue. Judges tend to do that in advance of the trial. That's what Judge Mershon is going to be doing between now and the start of the trial on March 25th. A small footnote to that, and that is that we'll always wait to see. But when the first juror is impaneled there, if this case is really going to trial, as we have seen in all of these other cases indicted, charged about a year ago, none of them probably going to trial this year. Anticipate that the March 25th trial will go ahead, but one never knows. All kinds of things can happen. Motions can be filed that for various reasons interrupt the natural flow of cases going to trial. Less likely now that will happen here, but we'll wait to see. We'll wait to anticipate the impanelment of that jury sometime after the case is called on March 25th and evidence is presented in April and in May and arguably into the summertime as well. So we talked about motions. We talked about this fact that the attorneys for both sides have this opportunity in advance of the trial to submit what are called pre-trial motions. They have pre-trial conferences, pre-trial hearings, and indeed that's also what is going on right now in the so-called Mar-a-Lago case. This again is the case in which the special prosecutor Jack Smith has alleged again in an indictment coming from a grand jury in Florida, that Donald Trump not only took but also retained, used, bandied about some of these documents, some of them classified, not all of them, to which he had no entitlement. And the status of the case right now is that although Eileen Cannon, presiding over this matter, did in fact have a hearing a little more than a week ago, anticipated at that time perhaps setting a trial date for that, she disappointed a lot of people by saying, you know what, I'm not going to issue a decision on that right now. Previously, she said that case will go to trial on May 20th. The charges in that case were first filed in June of last year. That date will almost certainly slip. And although it's right now still on the calendar, she has not told us with specificity what that new date may be. But what she is doing is she is entertaining these pretrial motions, just like in the Alvin Bragg case in Manhattan, the so-called hush money, the catch and kill case. She likewise is entertaining motions that are going to define the landscape, the geography of that trial, the Mar-a-Lago case, the documents case, whenever it goes to trial, which could be later this year, more likely sometime in 2025 after the November election. So what are those cases? What are those motions all about? Well, here's the big one. It has to do with selective prosecution. Selective prosecution. Prosecutors in this case, in the Mar-a-Lago case, are pushing back on the notion that this was involved in any way with a decision to prosecute Donald Trump selectively and differently from others who are similarly situated. How does this come about? The defendant in this case, the principal defendant, not the only defendant, but the principal defendant, Donald Trump, saying that he's a victim of selective prosecution and saying that he was being treated more harshly than President Biden was in an investigation into his handling of sensitive materials. And we've talked about that recently. The prosecutors, Jack Smith, have said recently that the evidence of potential wrongdoing against Donald Trump in the Mar-a-Lago case is, in their words, starkly different in two major ways. Very different from the decision not to prosecute the current president, Joe Biden. Very different in two principal ways, that according to the special prosecutor. In an array of these motions to dismiss this case against Donald Trump, the prosecutors are going forward and saying that there are significant differences between what is going on here and the decision not to prosecute Biden. You recall that the handling of classified documents was also the subject of another special counsel, and his name, Robert Hur. He released that very controversial report not too long ago, finding that there is nothing here. There's no intent, there are no charges that could possibly be brought, and determining that a criminal case cannot be made against the former president. We've also seen that the Department of Justice did the same thing with respect to the former vice president, Mike Pence. Mike Pence, likewise, the subject of an investigation in determining whether he inappropriately had classified and other documents. Similarly, the Department of Justice coming forward and saying no indication of intent there, no reason to believe that there is a reason to conclude that there was a criminal basis, a criminal motive for those two, that is the current president and the former vice president, holding on to those documents. And so, what in particular does the prosecution say about this selective prosecution charge, this claim by which Donald Trump and his attorneys are seeking the outright dismissal of that case? Well, prosecutors working for the special counsel have again said that while there's some superficial similarities, the differences are really actually very profound. Among other things, they say this: the volume, the sensitivity, and the storage of the documents all point in the same direction. This again from the motion responses being filed right now in the Mar-a-Lago case. They say that Trump's conduct was much more serious than that of Joe Biden, thus confirming that the two cases are not nearly identical, as the defense states, and that there are legitimate reasons for viewing them very differently. They added this. They said Trump has not shown that Biden's conduct, as described in her report, that is a special counsel report, makes him a similarly situated comparator, that is somebody whose situation you compare one situation to the other, has not shown that Biden's conduct makes him a similarly situated comparator for purposes of a selective prosecution claim. Now, selective prosecution claims are also notoriously difficult to prove, and the defense understands that completely. And the Jack Smith folks, the prosecution, understands it as well, because they require the defendants to show the government effectively discriminated against the defendants by charging them, but not charging somebody who is similarly situated in like circumstances. Prosecutors wrote in response to this motion to dismiss the case based upon selective prosecution that Trump's decision to hold on to these dozens of these highly classified records as if they were keepsakes, memorabilia, or trophies, to store them in an unsecure location and then reportedly obstruct attempts by the government to retrieve them, including through a grand jury subpoena, that all of that makes his behavior fundamentally different. And so the comparator, the comparison between the Biden situation, arguably even the Mike Pence situation, we've got none of that, and the Donald Trump situation does not in the end support a selective prosecution claim, a defense to the prosecution itself. That's what the prosecutors are saying. Again, it is a heavy lift. It's a lot of burden for a defense attorney to undertake. The request by the prosecutors to reject that Donald Trump somehow has been treated unfairly is only one of several other court filings brought also by the defense as a part of this motion practice. And the prosecutors also seeking to counter other motions to attack the law he is accused of violating. That is the underlying charge there. To question the legality, the very legality of the special counsel prosecuting him. To claim that the records he'd been charged with removing from the White House belonged to him, that he had a personal interest in those, and again, that he is immune from prosecution. When we come back, we're going to talk more. We're going to unpack those a bit more as well. As part of our analysis, our deeper dive, our more microscopic view of what's going on there in that case, right here on our Saturday morning broadcast. Microscopic analysis of some of these big stories coming out of some of these major cases. Right now, talking about the Mar-a-Lago criminal prosecution. No clear trial date set, although May 20th remains arguably on the docket of the presiding judge. She has not told the attorneys, she has not told us when this case will actually go to trial. It is significant in terms of its dimension. Unlikely, based upon the number and the series of things she's got to decide right now, that it will see the light of day before the election either. So joining probably the election interference case, probably the Georgia case, none of those going to trial. The one, once again, that may well go to trial later this month is that case in Manhattan. But in Florida, Eileen Cannon has before her these motions, one of them charging selective prosecution. Unlikely that in a merit-based analysis of that motion that a reasonable judge would grant that motion, dismiss the case. Selective prosecution, a very difficult thing to show. There are other motions also pending in front of her. Another one of those motions, the Trump legal team arguing that the charges should be dropped because of a claim that the Attorney General himself, Merrick Garland, had no legitimate authority to appoint Jack Smith in the first place, and that prosecutors working for him have no legitimate funding. And now, noting that there have been many special prosecutors appointed by attorneys general, the Supreme Court has recognized that authority explicitly in other cases. Jack Smith and the others defending against these motions have rejected that idea. They said this in their response to that motion about authority to prosecute. Each argument is incorrect, and neither supports dismissal of the charges that were properly returned by a grand jury in this district, reminding America that this case, like all the others, does not come from the desk of the Attorney General, does not come from the desk of a legislator or a president, but rather from a grand jury. The Trump attorneys also argue that the case should be dismissed because a law called the Presidential Records Act, that law makes official White House files public property, somehow allows presidents, before they leave office, to designate certain materials like diaries as their own personal records. Now, we know that that's not the case, that all those records are the property of whom? They're the property and the possession interest of the people of America. They argued that Trump's sending the files to Florida indicated that he was implicitly saying these are owned by me, and that there was no second guessing, if you will, of any of this because he understood those to be within his personal ambit to do this sort of thing. Of course, Jack Smith, once again, pushing back upon that fairly preposterous invocation of the law in this case as well, and saying that all of these claims rest on three fundamental errors, all of which, according to the documents, reflect the view that as a former president, the nation's laws and principles of accountability that govern every other citizen do not apply to him. In other words, discriminating between his situation and that is invoked with respect to any other defendant in court. Final motions out there, the Trump team arguing that, again, he's absolutely immune from prosecution because this traces back to his time in the presidency, and that, of course, brings us back to what's happening before the United States Supreme Court. Interesting argument there. They may be arguing that, in part, the taking of the documents from the White House happened while he was still the president, and therefore he's immune for that purpose. But undeniably, the great majority of the allegations, if not all of them, read clearly and dispositively, make it clear that the allegations happened after he was outside of the presidency. And so on that basis alone, Judge Eileen Cannon has a sufficient basis upon which to deny that motion alone. And that would even assume, of course, that presidential immunity is such a thing. That is what the United States Supreme Court is going to be hearing argument on the last day of its oral argument in April. That is what the Supreme Court is going to be telling us all about sometime in June. That could indeed animate the decision on this immunity claim, also now being raised in Mar-a-Lago in the documents case as well. Lots of motions pending there. Of course, Eileen Cannon also, as we've discussed before, has these issues about how to handle the national security documents. How do you handle those cases when classified documents are presented in a public forum, which is a federal court? All kinds of things have got to be addressed in a pretrial setting. Also have to deal very centrally with this other issue, which we've talked about a lot, and that the special counsel is very animated about, which is the disclosure of information about witnesses. The special counsel has said that Donald Trump has had this history, and indeed he has, in other cases, including this one, of intimidating witnesses, of threatening them explicitly and implicitly, and that process has prompted a violation, if you will, of the fundamental ways in which we try cases. It affects the jury process. It affects the jury pool. It affects the ways in which witnesses in particular are inclined to testify. And if indeed the notion goes, information is disclosed in the public domain about who those witnesses may be and where they are located, their home addresses, other identifying information, they too can be subject to threats, inappropriate threats, illegal threats by people, including people in the Trump ambit. And that will have an impact upon the administration of justice in this trial. If indeed they're chilled from testifying, if they're prevented from doing the kinds of things that we'd expect a witness to do, which is to testify honestly, completely, without fear of intimidation. That matter is also pending in front of Judge Cannon. She had begun to go down a road, pulled back after the special counsel indicated that some of her analysis was somewhat flawed. All of this needs to be taken care of course, before there is any trial that is opened, conducted with respect to the charges against Donald Trump. Again, broad charges, but significant in that they once again are dependent upon showings of intent and motive and purpose. And that's why the special counsel is pushing back on all of this that indicated that Donald Trump did not have the intent, did not have the motive, did not have the purpose when he took these documents out of the White House, nor did he have that criminal intent when he used them, moved them around, engaged in other things that were contrary and are contrary to the law as set forth in that indictment. Lots and lots to take on. Lots and lots to consider when it comes to the status of all of these cases. This morning, spending a bit more time, as we are going to be doing in future broadcasts as well, a bit more time diving more deeply into the nuts and bolts of these cases, a more microscopic look at the rule of law here on our Saturday morning broadcast. Join us again next Saturday for more of this analysis, analyzing the significant news events of the week in the areas of law and government and the aspiration for justice. Have a good week, everybody.